And we are live, and I'm going to roll this video. Hey, Mark, how's YouTube doing? Can't see your note there, Mark. Give me something in the chat. Thank you very much. All right, ladies and gentlemen, thank you very much, and welcome to Motor Carrier Self-Defense, broadcast to you live on Facebook and YouTube, brought to you by the Trucking Defense Network. Yes, that was Convoy from 1978. Starring Chris Christopherson, Ali McGraw, Mr. Burt Young, and of course the inimitable Ernest Borgnine as Sheriff Dirty Lyle. So thank you all for coming today. We appreciate you being here. We've got a very special show for you today because we've got our special guests, Mr. Doug Marcello, for the defense, and Mr. Joe Freed for the plaintiff. And our job here today is to study and analyze a case. and we are here to determine who else is involved in this case that is likely to be served with a letter of representation. And so what we're going to do is we're going to discuss the facts of the case. I'm going to put forward some presumptions about the case, and then we will discuss it from both the plaintiff side and the defense side. So without further ado, let me introduce for the defense, trial attorney extraordinaire from Harrisburg, Pennsylvania. Please welcome Mr. Doug Marcello. Doug, tell us about yourself and what your approach to defense means. I've seen you speak. We value your strategy. So tell the audience a little bit about your strategy in terms of the hit them first.
Well, one of the key things I think, Brendan, is, and you and Joe and I were talking about this before we went on the air, is to take a practical approach, a realistic approach. We will take responsibility for what we're responsible for. I think the biggest thing with the jury is credibility. And I think you have got to avoid doing things that cost you that credibility. Like we were talking on the air, I think one of the crucial things is, and one of the most important things for the trucking company is to respond to that accident immediately. In this sense, in this litigation, the biggest advantage we have is immediacy. And if we don't take advantage of it, well, we will have lost it. But what we want to do is to move the case forward, be aggressive in doing so, and investigate the case as soon as possible to determine, is it one we should settle right away, or is it one that's defensible? So that's kind of the overview on it, Brendan, in a short.
Very good. Thank you very much. As we say here, always rapid response leads to rapid resolution. That's our mantra here as well. Now, if I may, please, hold on a second. I'm going to exit that. Make sure I've got my buttons all pushed properly. Now let's bring it to Mr. Joe Freed. Joe, it's always a privilege to have you here because Joe is a trial attorney for the plaintiff. He is not your enemy. We know our audience is made up mostly of motor carriers and the companies who support and insure them. Joe Freed is not your enemy, but you should hope that you never have to oppose him in trial. Joe, tell us why you're here today.
That's like saying he's not your enemy, but he's not really your friend either. No,
no, I consider you a friend, sir. I really do, and I appreciate you being here.
I always say that when it comes to, we can be adversaries in a courtroom or on a particular case, but we should really never be adversaries when it comes to the concept of safety and helping this industry that we all love be better. The best way to do that is to collaborate. And frankly, it's the reason why I'm here, is to see if there's something that I can offer people who aren't used to hearing from someone like me. I'm here to share from my heart. I already know that I'm dealing with the real deal on the other side here. When he starts his presentation, the same way that I start just about every presentation. And that's that I say that in litigation, and that includes the investigation all the way up through whatever appellate work needs to be done. It's all just a big, giant battle of credibility. And so the party that's perceived as credible at the end of the day is the one who typically wins. And so so everything that I do, I try to measure against that sort of metric. Am I doing something that is going to improve my credibility and my credibility of my case and my cause? Or am I doing something that's going to be a net negative on the credibility or cause? Or vice versa, am I attacking something because it will cause a negative credibility problem for the other side, or vice versa, if that makes sense?
It does. It does indeed. And thank you very much. We value your perspective here because Joe, if you ask him to, will give you his playbook. He'll tell you how to prevent winding up on the opposite side of him in court. And so we are very privileged to have you here today. Now, we're going to talk about a case. And this is a case that occurred here in my hometown, West Denver, Colorado, on April 25th, 2019. And this man, a truck driven by this man, Mr. Rogel Lazaro Aguilera Mederos, a 23-year-old Cuban immigrant with a green card, driving a flatbed semi-trailer down I-70. He was eastbound from the mountains as I-70 rolls down the hill into West Denver. He was driving for a company called Castellano 03, and we'll get to the meaning of that name here in a moment. But here's the facts of the case. Mr. Mederos, driving his semi down the mountain, attracted the attention of passersby in other vehicles. And this section of I-70, as it comes out of the mountain, is the main traffic way for all mountain recreation. It is a 6% grade over a 7-mile stretch, which means that road elevation is dropping 6 feet down for every 100 feet forward. And it is a notoriously steep grade for trucks and truckers. I know this. I've traveled this road many times in my youth and my adulthood. So the area is marked clearly with runaway truck ramp signs. As you can see right here, you can see as he's passing this runaway truck ramp, the taker of this video said he should go on the truck ramp. He's 2,000 feet away from it. And we continue to follow until he gets to this point right here, where it is the entrance to the runaway truck ramp. We call this an arrestor bed, and it's effectively a separate lane of the highway that if your truck has lost its brakes and is speeding down the highway, you can pull into this lane, and it's full of pea gravel. And it's about 14 or 18 inches deep, and the friction from the gravel will stop the truck before any death occurs. You can see this is the point where Mederos has driven past the ramp. And by this time, he's driven past no fewer than 8 signs, 8 bright, visible yellow warning signs warning truckers about the grade. But he doesn't take the ramp. He veers to the left. He almost knocks that pickup truck off the road. And from this moment forward, Mederos has started his roller coaster ride to hell. And so, to give you a further example, let me get to here. This is as he continues down, this is within moments. This video was taken live within moments, or actually seconds, of the accident itself. So take a look at this. It's a very short clip, so pay attention, and you'll see how fast he was traveling when he drove past this traffic.
You're welcome, guys. We just cured anxiety.
Oh my God! Jesus Christ, we almost died.
Watch it again.
We just cured anxiety.
Oh my God!
So, Mederos traveled down. He missed the runaway ramp. He's now traveling down the emergency breakdown lane on the shoulder of the highway at speeds greater than 85 miles an hour. What he doesn't know is that up ahead of him is a traffic jam. Traffic at this point is backed up for miles in front of him, and he doesn't quite know it yet. But he hurtles down the mountain until he gets to the traffic. And as he continues down the mountain, he comes under Denver West Parkway here, and he sees this semi parked in the shoulder lane. He fears for his life, closes his eyes, and steers his truck into traffic. And the result is this mess that you see before you, in which 4 people lost their lives. May God rest their souls. So, those are the facts of the case as we know them. I'm just going to check and make sure that we haven't missed anything. Medeiros did escape serious injury. I happened to be traveling the opposite direction, westbound on I-70, when I saw this happen directly in front of me. I watched Medeiros get out of his truck, and I don't know, I lost him in the smoke. The scene was immediately engulfed in fire. It was an extremely violent situation. As we mentioned, Medeiros was driving for a company called Castellano 03. They were, at the time of the accident, they reported to the FMCSA that they had 5 power units with 5 drivers, totaling 436,000 vehicle miles traveled. They had 10 brake-related maintenance violations on their record. They had 2 driver fitness violations due to drivers unable to speak English, and they had one violation for failure to obey a traffic signal. Castellano 03 carried the minimum liability of $750,000, which of course will not make whole the lives of the families who lost their loved ones in this accident. According to the Medeiros arrest affidavit, he admitted to law enforcement that he had no brakes. Also, according to that statement, the truck in the left-hand lane, the driver informed police that he was there allowing his brakes to cool, and he was in the passenger seat at the time of the accident. Very good. Those are the facts. The presumptions we can make is that Castellano 03 has no assets, that there is no money back in Castellano 03. Transportation, it was a load of lumber. As again, I'll just keep this picture up here so that you can continue to see the mayhem that was involved here. He was carrying a load of lumber, which of course ignited very quickly, and that lumber was likely a 3-way transaction between a shipper and a broker and the motor carrier. Also, Medeiros is facing 4 counts of vehicular homicide in the state of Colorado. Therefore, no evidence has been released by law enforcement or the courts. And so with that in mind, no civil litigation has taken place to date or will take place until the trial is over in September. Also, in terms of presumptions, we can presume that any records of the shipping transaction, like the bill of lading that Medeiros was carrying, were destroyed in the fire. As known to date, no criminal charges or enforcement efforts have been levied or taken against Castellano 03. And Medeiros required an English translator in order to communicate with law enforcement, and he either was unable to read the warning signs or ignored them. Now, we're not here to talk about language barriers. We're not here to talk about immigration. We are merely here to discuss the case to determine who else might be named in the suit. And we'll get to that in a moment. But for now, Let me start with Doug Marcello. First of all, Doug, is this situation, from your perspective, in any way defensible?
In terms of the driver, no, I don't believe it is. It's a situation where he's going down the road. 15 years ago, when I started to focus on trucking practice, I got my CDL. And one of the things that was impressed upon me was, and I'm sure, Joe, you've seen this in the manual quite a bit, is the proper way for braking when going on a downgrade such as that. I read an article from Truck News not too long ago that was done, and the guy had a great point in there, which they drove home to us in truck school, which was brakes aren't meant to impede you coming down a mountain. You know, you use speed, gear, Jake brake, things like that. Your brakes are used to slow or stop you on a level grade. You can't rely on the brakes, and particularly with the drum brakes that we have on the trucks and the propensity, if overstressed, to overheat on that. So to start with, you know, the driver should have been operating in such a manner coming down that hill that he was operating with control of his vehicle. The language issue, I think, you know, whether or not he needed a translator on that, the requirement, as I recall from, you know, the standards on that, is that he has to be at least conversant enough to operate a commercial motor vehicle. So I think the ultimate test is going to come down to, was he conversant enough to identify those signs, and particularly the runaway truck ramp in that regard on that. So I don't see in this case the defensibility of the driver on that truck.
Neither do I. And I also have been a CDL holder for many years, and in Colorado, and nothing causes me more anxiety than the prospect of driving a semi through the mountains. We say here, around here, for all our truck drivers, you can go too slow down the mountain as many times as you want to. You can go too fast exactly once, as was proven by Medeiros this day. So, Mr. Joe Freed, $750,000. 4 families lost loved ones. Where do you go? Is there any money in this case for you at all? And I'm going to ask about the shipper specifically and the broker, because these are a part of our audience, and I want them to understand, is there any negligent entrustment on this part, or does Paulsgraf versus Long Island Railroad play any role in this? Take it away, Joe.
Well, I think, let me take a step back. I mean, if I analyze this, I agree. I think, you know, the first thing that's always present is to look at you see what the driver did, and you know, this is pretty abhorrent conduct. But there's lots of questions that I would want to know, because frankly, I'm always looking for the systemic reasons, the systemic causes that are setups for why something like this might happen, that go beyond that initial driver conduct. And a lot of times, frankly, in my cases, by the time we're done examining those, you really see the truck driver in this situation as somewhat of a victim of some other systemic issues. But if we're going to focus specifically on how am I going to look for more money in the case, and I think you're hitting on something, you're being kind in the way it's done, but I'll just be very open about it. My job is to recover what I can for the families in a situation like this. And if there's not going to be adequate coverage on the driver of the motor carrier, it's part of my training, and it's part of what I teach lawyers around the country, is how to look for other places where there's potentially coverage. And so we look for the primary coverage, we look for any excess coverages, we look for coverages that may apply. Remember, every piece, the truck is a commercial motor vehicle, each trailer and the dolly are commercial motor vehicles, the chassis is a commercial motor vehicle. And if all of those parts and pieces in a given circumstance aren't owned and being operated by the same exact company, oftentimes there's insurance policies that apply to those vehicles, those other attendant vehicles. The chassis might be part of an interchange agreement. there may be coverage on a trailer that's being towed by one motor carrier or hauled by one motor carrier, but it's owned by another motor carrier. And a lot of people make the mistake of thinking, well, you have to then assess liability against those parts. And sometimes that can be true, but in most of the insurance policies, those policies provide essentially secondary coverage as long as they're attached to a tractor in transit. They just provide a secondary form of coverage. So that's the first place I look to see if I've got my coverage from everybody possible there. Then beyond that, we do start to look at anybody else who's in the transportation cycle who might have contributed from a systemic perspective in some way that makes sense, that there's a legally viable claim against. And sometimes you see it and sometimes you don't, and we would need a whole lot more facts here to see it. But what you're asking to focus on is, could you have liability against a broker? Could you have liability against a shipper? Those are two different analyses. They interplay to some degree, but they're two analyses. And people who know the transportation cycle know that there is liability that can attach under certain set of circumstances. And I don't know how much you want me to get into that, but I'm happy to give a minute-long summary of that, or we can just talk about it as we go.
I think we would. One of the things I want to point out here is you mentioned that you believe the driver Medeiros is a victim in this, and you also mentioned systemic practices. And I believe it's a valid presumption to make that Castellano 03 is in itself a systemic problem. And I can also presume that this driver likely had no mountain training. He did have a CDL. He's from Houston, Texas. He's actually from Cuba, living in Houston, Texas. He's married. He's 23 years old, and he's just a dumbass kid trying to make a living. And somebody tossed him the keys and said, "Go to Wyoming and pick up a load of lumber and bring it back to Texas." And he said, "Well, by golly, I'd be happy to do that." And so I think those are some very valid presumptions to make. The man has been he's been demonized in the media here, and he will be demonized in court, being under 4 counts of vehicular homicide. My trouble with that is that whoever was running Castellano 03 is apparently skating away scot-free with no criminal charges and no civil litigation. And it's my belief that the number 03 appended to their name probably indicates a chameleon carrier who's been shut down before.
Yeah.
And so, okay, I know we've got some brokers out here, some freight brokers here, and, we've got this system of bottom feeders taking place that I call bottom feeders. And one of my mantras you'll see me posting on social media is, don't feed the bottom feeders. So some broker brokered this load of lumber, and they handed it to the only carrier they could get. We all know capacity's stretched, so-called driver shortage, which we're also not going to get into today. But how about that broker? Are they feeding the bottom feeders, and are they exposed here?
You want me to take a stab at that? I'll give you. So the answer, of course, like everything in law, is it depends, right? That's the traditional lawyer answer to everything.
Yeah, we're not in court, Joe. We're not in court. I'm asking for your supposition, your opinion.
Yeah. So here's
rules.
You made a few really good points as part of your factual presentation, or some of the facts that would be needed to try to be discovered. That bill of lading that may have burnt up, or any trip-related documents that may have been burnt up. I'm still going to go try to. Most of those kind of things can be reproduced. We need to look at hours of service. We need to look at all kinds of things in here. But if you're looking specifically for the broker, there's a couple of ways to go after a broker. I'll mention 3 very quickly. The first one is when the broker, although they're licensed as a broker, they're really acting as a motor carrier. They've accepted the load as a motor carrier, and then they turn around and broker that load out. We see that increasingly, and we see it done illegally and improperly.
I'm sorry, would you repeat that, please, for our audience?
Yeah, there's a proper way to do this and an illegal way to do it. But if you do it improperly, if you do it any way other than the perfectly proper way, my argument is that you remain a motor carrier, not the motor carrier responsible for the load. You accepted that load as a motor carrier. The documents show that you're the motor carrier. Then you turn around and broker that load out. If you don't do it right, you remain responsible for the delivery of that load. Whoever you choose, whether you do a good job, bad job, any job, it's whoever runs it ends up being treated as if they're your employee in a statutory employee situation. That's way number one. And I'll tell you, I'm not going to mention any names because I've got a lot of respect for people, even a lot of people who I end up suing. I sue them to fix a problem. But one who's become a friend of mine recently at a very large trucking company, they were taking loads in. They thought they were doing it right. They had broker authority. They honestly thought they were doing it right, but they left themselves in a terribly, terribly exposed situation because they just weren't following the proper rules. And they ended up being, even though everything looked like a broker, my position was you're a motor carrier, and I can get to all of your coverage by virtue of your motor carrier coverage. And they ended up paying us in a case that they didn't think that they needed to. But by the end of it, that guy's now become a friend of mine. He actually called me when we were done with the litigation, and he said, "I just want you to know we've changed our whole system over here, and it's important for me that you know that this case made a difference, and I think the family might want to know that too." And the family was happy about it. But that's way number one. You're actually the motor carrier. Way number two as a broker is essentially when you hire and this is what you were talking about, the bottom feeder, I think. You're hiring the cheapest, person to run the load, and you've done no due diligence for yourself on the process. So you end up hiring somebody who's got all these prior violations. Maybe they're even out of service. Maybe they're unsatisfactorily rated, all kinds of other things. And you get tagged as it's essentially a negligent hiring case, but you're the broker in this scenario. The third way, that was the one that most people understand, frankly. The last way, which people understand less, but it's still very important, is just what's called a control theory. And if you're the broker, and this is C.H. Robinson even, is the biggest cases of these have been cases that have broker names that everybody knows. Because of their contracts and their actual business arrangements with the carriers that they do business with, if you cross a line and you are exercising what the law deems to be too much control over the time, method, manner, and process, that motor carrier is required to go under to perform their duties, then you become, by virtue of that control, there's a theory where I can tag you and hold you responsible. And so there's a big fight, and the industry is working right now kind of to figure out what best practices are so that they try not to run afoul of this. But part of the problem in trucking generally is that you don't always have uniform things happening from state to state, even though trucking is largely interstate. So you have a difference.
Very important. I think what we're going to have to do, Joe, is bring you back at a later date, because we could spend a whole hour just on control theory and those 3 points alone, and I think our audience would find it very informative. Doug Marcello, who are you stepping up to defend here?
I only defend those who ask me to do so and engage me. If that's what you mean, Brendan. But, I think what we're looking at here, and I think Joe correctly says, and people go, well, lawyers always say it, but a lot of it in terms of the defensibility of these, as Joe said, depends, and it's going to depend a lot on the facts that come out. A lot of these, determinations of motor carrier, broker, shipper, the responsibility levels, go to the dealings between them. A lot of these issues are attempted to be defined ahead of time, contractually, with regard to shipper contracts in terms of CSA scores, other elements on that. So I think a lot of it goes into the background on that of what they have. One of the other things I think that Joe made an excellent point on is that many folks don't appreciate the trucking companies is the policy language on their insurance policy as to what is in those definitions of a motor vehicle or definitions of an insured covered, even though they said they don't anticipate that it's being covered because they're not the power unit pulling the load.
Aha. Very important information. So really, and there's another case that recently happened where a motor carrier went out of business because of this, and it seems like it comes straight down to paperwork. If you got your paperwork straightened away, then you stand a better chance of defending yourself, because that's what this is all about. That's what the Trucking Defense Network is all about, is identifying these pitfalls where our clientele have a tendency to fall into, and then informing them of the pit. Because if you can see the hole, you don't necessarily have to walk into it. Let's move on.
My thought on that, Brendan, and Joe, I appreciate your thought, is I think the paperwork can greatly help and lay out the relationship as long as the parties live up to the paperwork and follow and act consistent with it. And it's not just a cover, let's say.
It's such a big point that Doug just said, because sometimes people will have paperwork and it's the foil out here. And imagine what somebody like me is going to do when I expose the foil.
To me, Joe, that's worse than not having anything, because it looks like you're trying to pull. Yeah.
It's 1,000 times worse, because now it's a premeditated, you knew what the hell you were doing. You built this only to try to play this protectionistic game. And you did that. And then you instantly went and put these other real world practices into place. And those are the kind of things that then there's a nuclear verdict and people are scratching their head and say, well, gee, man, I mean, the wreck really, the driver's conduct really wasn't all that bad. I mean, why the hell, or there was so much liability on the plaintiff. How could people avoid looking at all the comparative fault on the plaintiff? You know why? Because they didn't really give a crap about that, because what they're really awarding the number on is they're so pissed off about the foil and this company's effort to try to play a game, and they got busted. So it's kind of like what I'll call a little p punitive damage award. It's not punitive damage award for, that gets taken away from you, by the way, by the appellate courts. It's just you could say little p punitive damage. You can also say little p pissed off jury, right? I mean, real people. And I'll tell you, folks, don't, some of you are saying, well, I would never award that kind of money if I was on a jury. You'd be shocked. You talk to jurors. It's people from all walks of life, no matter how conservative or liberal they are, no matter what color of their skin, no matter all these issues that we now, find as points of divisiveness in our society, they will come together when they get pissed off about some company looking like they're playing a game. So folks, I'm looking for the games you're playing. So you want to protect against this? Stop playing the games. Just do this the way the industry is trying to give you all, and the resources are out there to do it right. You playing Russian roulette, well, eventually it goes bang.
Joe, I thought the best example of that, and it goes way back to earlier, was when Jerry Spence did the first bad faith case in California, and he left the vice president of an insurance company on the jury. And his thought was, and it turned out to be true, that vice president was as offended, if not more, than the other jurors by the conduct of that other insurance company on there.
I leave truckers on my case, and they'll say, "You're crazy. You don't want me on your case." I go, "Oh, I want you, because you know if I'm going to be trying to pull the wool over anybody's eyes. You can tell everybody I am."
Yeah.
So by the way, Jerry Spence is one of my friends and mentors. I give him a lot of credit for making me the lawyer I am today. So.
Very good. Joe, go ahead, Doug.
I'm sorry, Joe. Did you ever see a nuclear verdict where there wasn't something that pissed off a jury?
No, I think that's the whole point. The whole point is, so, when I stood up at DRI and said this, I said, here's the problem. I said, I grew up with a mom who said, when you're pointing at somebody else, you're pointing 3 fingers back at yourself. And I said, folks, I've got huge respect for lots of you in this room, but when you want to blame that dumbass juror number 4 who wasn't exactly honest on jury selection, or this judge who I knew she had it out for me the minute I walked in the door, or this unfairness out there, it's all external, it's always someone else's fault. We can't really get better when we do that. And you're part of the freaking problem. And I say it to plaintiffs lawyers all the time, man, you got to look at yourself. What did you do? And sometimes I feel for people on your side, Doug, because the system is set up to where you've got handlers. I mean, you've got people at insurance companies who, God love them, some of them are 25 years old, and it's not an age thing, but probably a 25-year-old claims manager is probably not the best person to manage Doug Marcello, who's been around a little bit longer than that. I don't know how old you are, Doug, but you look like you're a little over 25. Okay.
Too old, Joe, too old.
But here's the problem. When you're the defense lawyer, if you go out and do something different, and God forbid something goes wrong, you will be plastered for that. You're going to get sued for it. You're going to lose business for it. You're going to be made to look like a dumb you-know-what for it. So the centrifugal force is to pull you into staying with the status quo of how these cases have been handled forever and ever and ever. And at least, even if I lose big, if I did it the way we normally do it, I won't get hurt. In fact, maybe I'll even get more business because I'm now responsible for, I'm the kind of lawyer who works on $100 million cases, right? So that's part of the problem is that the system is set up to where even on your side, within the people on your side, you're adversarial. You got somebody who's trying to cut your fee. You got somebody who's trying to tell you what to do and not do. It would drive me batshit crazy. Excuse me, that's a technical legal term. But there's no way I could operate like that. I couldn't do it.
And Joe, let me say, Joe, you're absolutely correct. And it's taxing. And in terms of, I try to look for new and different ways. A lot of times the biggest questioners on those are the insurance company in terms of what are we doing? Has it ever been done before? And just a general risk aversion. I appreciate their responsibilities. But it's like, I use the example of the American hockey team in 1980. Herb Brooks goes, look, the Russians have been kicking our tail for 40 years. We keep doing it the same way, they're going to kick our tail again. We got to come up with a new way to do it and a new approach on that.
You guys are both singing my song here because it's a personal tenet of my own that none of us is the product of our circumstance. We are the product of our response to circumstance. And when we make these complaints, when we talk about tort reform, or we talk about the billboard lawyers, and this is what I hear from my clientele all the time, the billboard guys, and I know you're not a billboard guy, Joe.
I've got a face for radio, man.
No nonsense. But where was my point going on this? When we complain about tort reform because we're losing the game, to me, it's equivalent of an NFL coach complaining to the league because their quarterback got sacked. And we're just not playing the game well. And that's our mission here, is to bring our clientele to play the game better and be better at it, be better operators, safer operators for starters. But then when something bad does happen, to make sure we are putting ourselves in a defensible position. And that's why I have you both here today. Let me move on here, though. That was fascinating discussion. But really what I want to look at now is this guy right here. Okay? He's parked on the side of the road. What are you going to look for in terms of cause and effect on this semi on the shoulder in a traffic jam? Bear in mind that this is stop and go traffic for 3 miles further east. Okay.
He's mine, man. I'm taking him.
Yeah. What are you going to do, Joe?
Well, here's well, first of all, what I'm always doing in these cases, and Doug will appreciate this because I did the same thing he did when I got into trucking. I went to sit my butt in the truck in the cab of a truck. I now actually teach. I'm a teacher at a truck driving school now. On top of doing that. You don't want me. You don't want me out there actually driving a damn truck. But I got a lot better at backing up my boat from my training in a truck. I am unqualified. I'm an example of what it means to have a CDL and be unqualified to drive. But the point that I'm making is where I'm going to is a big part of my world is to explain to people who have no background, no understanding of the trucking world, why something is a big deal when you're in a truck that's different than when you're in a car, and why it's not that the standard of care is different, because we're all governed by the same standard of care, but what it means to be reasonable when you're driving one of those trucks is different than what it means when I'm driving my car or somebody's driving a moped. I mean, it's just totally different, right? So the industry knows about the dangers of being on the shoulder of the road. They know about the fly to the flame effect of things. They know about how dangerous it is. And so really, this guy has got to have a really good explanation, because he's also supposed to know his circumstances. And he's at the bottom of a hill. He's not in a danger point now, unless his brakes are so overheated that, there's other issues we could be talking about. If he's in a spot where he feels like he needs to stop, I don't know how far the next exit is. I don't know how far the previous one was.
There's a truck stop 1.5 miles down the highway.
Yeah, so he's going to have to sell to the world that it was less dangerous for him to stop here than to drive another 1.5 miles down the road. And unless there's factors that I don't know about, he is not going to like the way that comes out at the end of my examination of him. And his trucking company is going to have to make a decision. And Doug will appreciate the way I'm saying this. Have to make a decision about whether they're going to endorse this conduct or they're not. And you can see how I'm going to make that an important decision for them to make in the case, if I'm in a jurisdiction that allows me to do that. And jurisdictions aren't all the same. But people don't know, maybe even people in this industry, maybe even brokers who are watching this right now. If you don't have specific driving experience yourself, or you haven't studied this safety issue, parking on the side of the road, big, huge freaking problem. There are so many wrecks every year. It's one of the number one things, even if you go to the ATRI studies, you go to all the top 10 problems in trucking, you hear about things like shortage of drivers, you hear about parking issues also. And the fact that this guy's sitting in the passenger compartment, it makes me want to ask all kinds of questions about what was he really doing? How long was he there? Is he listing himself still on duty? Is he listing himself? The truth's going to come out somewhere along the line, and he's got an ECM that I'm going to be able to read, see how long he's been there.
That unit did burn to the ground. Everything you see there, this footage that you see here is within 5 minutes. This is prior to emergency responders arriving. Wow. The news choppers happened to be there because there was another crash 2 miles up the road. And so as soon as they figured it out, they just flew their bird a mile, and there they are before emergency response. So hours of service. Doug Marcello, how do you defend this?
Well, you start off, of course, getting the data. And even though the unit burned up, the question number one, in terms of what type of VLD do they have on there, and is it continuously transponding? And is that data being collected off site, which I anticipate it probably is for most units.
You can be sure of that. You can be sure of that.
Number two is, does it have telematics on it? So is there going to be an Omnitrax unit or something like that on it that's going to tell me what Joe's asking, that positional history over that period of time? Mm-hmm. Number three is we're going to have the other, and as Joe indicated earlier, the paper documents are usually backed up somewhere or something. So what were the supporting documents with regard to his operation that day that we're going to have and know about in terms of where he was going? Mm-hmm. Now, in terms of parking on the side there, was the backup Brendan continuing up ahead of him beyond where he
Yes, the backup was at least 2 miles ahead of him.
So the question comes up, and I think Joe probably has the same question. You know, if your brakes were overheated, you need a place to stop, you got a traffic lane full of vehicles, why pull off the side of the road to do that? As opposed to, you know, unless you're potentially looking for some other reason, as Joe pointed out on that.
And
Joe, one of the other things I was going to ask Joe is, and something that we didn't talk about in the hypothetical, how about the lead accident, Joe? Would you look at that as well? Because I've had a couple cases that way, and I've argued to the contrary, where I've been the lead accident or the lead problem in terms of remoteness on it. And I think it comes down to a factual issue. But I would assume that's one of the things you look at in terms of that lead accident as well as a causative factor.
I thankfully have not thought about Paul's graph versus Long Island Railroad in a long time until Brendan threw it in. For those.
And Joe, I haven't thought of it for much longer than you have too. I had flashbacks.
Yeah,
I felt like I had to stand and recite. So no.
I suddenly snapped to attention. It was crazy. I think I have PTSD a little bit right now.
Really?
But for those who don't know, I mean, that's the case that is sort of the seminal case that addresses this legal concept of proximate causation, which means you have to be the cause of something, and sort of how close a causal connection does it have to be? And you can imagine, I mean, you can kind of get crazy with what the cause is. I mean, is the fact that you woke up 10 minutes late the cause for the wreck that you have 4 hours later because you would have been 10 minutes ahead of schedule, you know, ... Maybe that's not enough. But so we don't need to get into the facts of Paul's graph, but I think it goes to this point. And the point is the wreck up ahead. My answer to that is I do look because I want to be thorough. I look at everything. And for me, and I'm admitting, I'm going to own this, as Brendan knows, I just say what my truth is, and some people might think
that's what we love about you.
Whatever, but so I'm going to look at that wreck, and if the facts that resulted in that wreck are bad enough, then I will consider making that claim. If it's just a typical run-of-the-mill crash, then I think I'm going to lose that, and it goes back to that idea of credibility. But if the underlying things that caused that other thing up ahead are just ridiculous and people are going to get pissed about it, then they're going to want to blame them, you know?
So, Joe, if I told you that in that primary accident that there was a semi-tractor trailer involved, would that pique your interest?
Well, that doesn't, you know, obviously, I mean, I think part of what you're saying there is if there's a truck, am I more interested? The answer to that is any wreck. If you tell me there's a truck, I'm more interested in, but that's because that's what I do. I mean, it doesn't mean that I'm, you know, it doesn't mean that I'm looking at them differently. I mean, I still think the truck will have, if the truck's responsible for it, it's going to have to be a big truck. But also part of this, and I would not be being fully true and fully transparent if I didn't say it. Why are we looking at this stuff at all? They've got 750 in coverage, right? I mean, if you had 750 million in coverage, I'm not going to be looking at that. Now, does that mean that you are making a mistake buying good coverage? I think the answer to that's no also, because, you know, if you have to properly insure yourself, I view the amount of insurance you have as a safety issue. You know, and we could talk about that sometime, but I don't want to take up the time now. But that's to me, the whether I go to that vehicle up ahead, I have seen it, I have done it, I do it in a very reserved context. And to me, the differentiator is how bad was that conduct up ahead, if that makes sense, Doug.
Absolutely. And I think it's a very balanced approach to it, Joe. Again, it goes back to what we started with. It's a matter of credibility. Right. And there are many times I see plaintiff attorneys totally different than you who feel that if they have an explanation for something or they have come up with a story for something, that's all they need to do. And, you know, they're the easiest ones for me to defend against because, you know, then it just raises questions about the rest of their story, even the legitimate stuff on that. You know, I think you got to err on the side of maintaining credibility and not give it away.
I totally agree, and it's counterintuitive. People don't think that. I think credibility is also cumulative in the way that you're talking about, but not only in the way within a case. It's cumulative with everything you do. So
Exactly.
when you go and you do something that lacks credibility in case A, 4 or 5 cases, case E that you're involved in down the line, you're still going to pay the price for that credibility crap from way back when. And that's true on both sides of the V. So
Absolutely. Nope, absolutely.
Credibility is cumulative. Let me say that again, my friends. Credibility is cumulative, and it's cumulative in everything you do, everything each of us does. That could be the key lesson to take away from this today. Let me move on here. We know that there's a criminal trial pending against this driver, and the state of Colorado is going to get their pound of flesh out of him one way or the other. Let's talk about that for a second. And I know neither of you are criminal attorneys, but this is armchair quarterbacking we're all doing here. So I'm interested in knowing, now that we've talked about the truck on the shoulder, number one, do you think that's going to have an effect on the outcome of the criminal case? And number two, how does the outcome of the criminal case affect the outcome of any downstream civil litigation? Doug, will you start on that one for us?
I think the most basic is criminal conviction or guilty plea is going to be negligence per se to start with on that. So that'll be the starting point. The second impact on it is the potential for obviating any Fifth Amendment defense at that point, because he faces no more criminal jeopardy on that. So I think there's a question of him being able to take the Fifth Amendment on it. Your thoughts on that, Joe?
yeah, I mean, while the reason why this is not moving forward on the civil side right now is it might be because a court has ordered that, and I've seen that in a few parts of the country. But the other reason is if I go right now to take this driver's deposition, he's just going to plead fifth to everything, and I can't really question him. I don't, some lawyers in my position think that's a fun thing to do. I would rather just wait personally and go and take the deposition at an appropriate time. And so courts are it's one of the things about the United States, sometimes people don't really realize that, we afford people who are charged even with very serious things like this, tremendous protections. And sometimes it can even go to the point where, imagine I'm representing these 4 families and they've got huge needs to know. I mean, they're struggling every single day. And yet we will put the right of the criminal, the potential criminal, the accused, will put their rights on this process that we have in the United States above that painful place for the plaintiff. It's sometimes very hard for my plaintiffs to accept that. But I'm proud to be in a country that has protections in place, that we really do try to live up to this idea of somebody's innocent until proven guilty through a system that we force them to go through. So it's a pain in the butt, and I look for ways around it in every case, but I respect the system.
Yeah, and innocent until proven guilty does have a tendency to stand up in criminal cases. I think one of the perceptions going along in trucking is that we are all guilty until proven innocent, and so that we may have earned that, we may not, but it's out there.
Hey, try being a plaintiff's lawyer for a little while.
Fair enough, Joe. Fair enough.
I think, Brendan, one of the key things of the trucking company comes down to reputation. And reputation is not just of the industry itself, but it's what I would call the reputation of the trucking company, borne out by their CSA score, borne out by their driver hiring practices, borne out by what the inspections are. And so the thought being that many companies, if they would pay attention to and focus on their reputation prior to the accident, that it would diffuse or take away while the accident might be horrific, such as this. If they've attended to their reputation prior to this accident, then Joe, I don't know your thought, but I think it makes a nuclear verdict highly unlikely. If it's like, look, this company did all they could, and their reputation, indicative of what their safety, hiring, and other practices are they tried to do the best they can. It's an accident at that point, and it's a matter of negligence, not negligence.
Well, I so agree with that, and it's funny because you see reform efforts going on around the country, and I understand the reason why people think that way, and that's not the subject of today. But a lot of times what you'll hear is, we don't want somebody to be able to look back at such and such and such and such. And I'm like, please don't do that. Not because I'm a lawyer and I want to be able to do that, but do it because, I mean, you talk about protecting, incentivizing people to not deal with their problems. That's the worst thing we can do from a safety perspective. We want people, I always tell people all the time, people complain about this reptile theory and all this kind of stuff. And I'm like, why don't you just use the reptile theory against the plaintiff? All you got to do is act right. Do it. Make me the bad guy. But to do that, what you have to do is now you have to steal my credibility to come in, and you're not going to be able to do that if your trucking company is not done what you're talking about in advance. Pay money for trucking safety on the front end. Look at it not as a something that you have to hold your nose to do. Know you're doing the right thing. I see Mark Tuckman on here. He's always saying, just do the right thing, and it's going to come back and save you down the line. And it's so true. I mean, people say, what about, should I have a drive cam or should I not have a drive cam? Or drive cam's good or drive cam's bad? Drive cams are just a damn drive cam. It's what you do that's good or bad. And
I think the key
buries you.
And I think the key, Joe, is to get ahead of it and do the right thing before the accident. Because after the accident, you can do all the right things you want to do, but that's backfill at that point.
I agree, but I will tell you, and I've gotten to know Brendan a little bit and what he does with the work that he does after the accident, and that's important. Also, I totally agree. Not to take away from your point, which I agree with, but two
different things. Because what Brendan's doing is dealing with the immediate situation. Yeah. So we've got the trucking company, doing its own reputational analysis beforehand and working on doing the right thing, and then we got a situation. It's an accident. And there's a question of liability, question of issues there. And that's where Brendan can be invaluable in terms of making sure that the proper information is preserved, addressed, and proceeded with at that time. Immediately after the accident, our biggest advantage.
Yeah. But it's warmed my heart. The more stuff I've done on this side of things, so to speak, as opposed to stepping away from sort of my plaintiff side of the world, the more I've been, it's been nice for me to see meeting people who really, frankly, they're no different than I am. I mean, in the belief about, advancing safety and it just being good business, and it's time to do it. And, I tell people all the time, I remember as a little kid, man, I was a truck little kid. I loved trucks, man, when I was a little guy. And, I'd get excited every truck that would come by. The only problem is I couldn't say TR and I said F instead. So I embarrassed my mom a few times along the way. but even back when I started driving, I remember my dad saying to me, if you're ever in trouble on the road and you need help, a trucker will help you. A trucker will help you. Now these days, there's no parent tells you. Parents of truck drivers don't tell people that. So what's happened in the industry? And come on, folks. You should want to steal that back. And that's where the focus needs to be. Is let's bring respectability back. But it requires. It's not my fault as a plaintiff's lawyer that this industry has digressed to where it is. But yet people would rather point at me and say I'm the problem than to look internally and to say, how can we improve this so that we're not going to stop wrecks from happening. They're going to happen every now and then. But what a different outcome, if you can stand up and tell a good safety story.
That's what we're here
set
for.
That reputational background to it.
Yeah.
Brendan, we've carried you over the hour, haven't we?
We have. I just want to mention, and we're going to wrap up right here. I want to mention that, Joe, you can't steal that credibility back. It has to be earned. So we are coming up on the top of the hour. Final thoughts, Mr. Doug Marcello.
Well, I think the key thing is it starts with the company itself, the reputational analysis, evaluate where you are, preserve that credibility and reputation by doing the right thing. And with that quality reputation That's your best defense against a nuclear verdict doing that. And I think, Joe and I are both in agreement. The best defense of these cases is great safety and protect, the people on the highway, the families, mine, yours, and all want that. And it starts with an analysis and defense of that reputation up front.
And it's true for your brokers and your shippers too, Brendan, the ones who are listening. If the what hits the what, I'm coming in saying, are you proud of putting this truck, this driver, this vehicle, this equipment out on the roadway? Are you proud of it? Not only because you made a good deal, quote unquote, for the movement of the freight, but are you proud of them? Because if you can't be, and I find a way, and all I'm doing, folks, is not that hard. All I'm doing is say to people, follow the money, and you're making money. So you better, the way you cover yourself is you require the good, you hire somebody, even if it costs a tiny bit more, you hire a better carrier. You watch for the people who are good and don't feed what did you say? Don't feed the bottom.
Don't feed the bottom feeders. Very good. I got to tell you, gentlemen, the longer I do it, the more it feels like parenting. Raising children. So I can't thank you enough, both of you, for coming. I know you're busy men and making the changes that need to be made in the industry. Thank you so much for being here. We'll have you both back again. This has been an incredibly valuable discussion. I think our audience has been appreciated, as we can see in the comments. So tune in next month. We will be talking about cell phone forensics with Mr. Larry Daniel from Invista Forensics. So we're going to inform you, our audience, about what is and is not available on your driver's cell phone post-accident. Everybody, thank you very much. Have a great day and safe travels, everyone.
We're not